crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis, Wright.
Good evening and welcome into the attorneys. Thank you so much for joining us tonight. Got a really interesting guest and panel here to deal with the topic criminal defense and criminal law and DUI. So I know you have a lot of questions. This is the kind of stuff that's on those TV shows all the time. So we're going to separate the fact from fiction coming up in just a bit. But before we introduce tonight's guests, I want to remind you of how you can join our conversation. Easy to do so, scrolling on the bottom of the screen all throughout the program tonight. Also, if you would like to text us, that number, if you want to write this down, 205-670-1949, or you can call us toll-free 844-LAW-TALK, 844-529-8255. Leading our conversation tonight, Carter Clay from the firm of Hollis, Wright. Good to see you, my friend.
Good to see you, David. I hope you're doing well.
I'm doing well, thank you.
Yeah, I typically like to start these shows out by saying we're covering a topic that's going to be relevant to all of the viewers, but I think it would be in poor taste to actually make that statement here tonight. What I can say is, like with our firm where we handle personal injury matters, our guest tonight, John Linton, primarily focuses his practice on criminal law matters. So hopefully this topic is not relevant to most of the viewers, right. But if you find yourself involved in an accident and hurt, want to call our firm. If you happen to find yourself in a situation where you or your family member are unfortunately charged with a crime and arrested, John Linton is the person to go to in this area. He is a fantastic attorney. Been practicing for almost 30 years.
32 years. Yeah.
32 years, and primarily, if not exclusively, in this area.
That's all I do is criminal law and local municipal courts, state courts, and federal courts.
And I told you before we got started here this evening that I had a funny story. So I was at Cumberland from 1996 to 1999. And John was there and has been there really ever since there. I think you mentioned 27 years helping out with their trial advocacy program, basic skills in trial advocacy. And I can remember, I believe it was when I was a second year, we were all talking about who we got for trial advocacy. And somebody says, well, I got this guy named John Linton. Everybody's like, oh, you got John Linton. Oh, he's tough, but he's really good. He's tough, but he's really good. But I say that jokingly, but at the same time, if you are a person out there charged with a crime, it is a very high compliment to say, my lawyer is tough and good. Because as you know, these individuals out there, they have an uphill battle. I mean, they don't have the resources that the district attorney's offices have. People's knee-jerk reaction is not you're innocent until proven guilty. It's guilty, and then you got to prove you're innocent.
Absolutely.
Which is not what our Constitution says.
No.
But at any rate, that is a high praise to you as a criminal defense attorney in this area. So I wanted to tell that story because I remembered it, even though I've been out, I guess, right at 20 years now.
Well, I appreciate it. You know, it's I've been teaching there for about 27 years. I think I started in '92. And you know you're getting older when now I'm teaching other students that I went to law school with their children. So one of your associates, Michael Eldridge, I taught.
Yeah.
So it's been a pleasure to be a part of helping the careers of some fantastic trial attorneys.
This is a commercial now for Cumberland School of Law. We'll be sure and send this.
That's right. That's right. Well, let's dive right into the topic that we're covering here this evening. So obviously, I like to start out when we talk about criminal law, they're typically divided between felonies and misdemeanors. So talk to the viewers a little bit about what is the difference between a felony and a misdemeanor.
It's really about the potential sentencing range that a person can get. A misdemeanor is any kind of an offense that the maximum possible punishment would be up to a year in a county or municipal facility. Whereas with a felony, we're talking about a sentence range of a year and a day, depending on what you're charged with, all the way up to potential life without parole or the death penalty, given the particular offense.
Now, so in the civil practice, which is what we focus on at our practice, of course, a lot of the causes of action grew out of common law, and there are some statutory Alabama statutes that allow causes of action. In the criminal world, is everything pretty much what I call codified or in a statute of some kind?
Absolutely. Alabama codifies virtually all its criminal law under Title 13A of the Alabama Criminal Code, or the Alabama Code, and that basically sets out almost all the criminal law and criminal offenses in Alabama. Now, there are some intermingled with the Motor Vehicle Code is something different in Title 32, but generally all criminal offenses are under Title 13A, and they're all statutorily set up by legislative mandate. Once the legislature passes a law, it becomes an offense, and it's all codified in rule or Title 13A.
Now, if somebody's charged with a crime, it's either going to be charged through the state court process or the federal court process. Talk a little bit about the different types of crimes or charges that are handled through the state court process and versus the federal court process.
Well, everybody should know that there are both criminal offenses, both on the state level and the federal level. State offenses, usually are violations, obviously, of state law, such as robbery, theft, murder, whereas federal law will encompass some crimes that are under state law, too. There is robbery under federal law of a bank, which can be both a state offense and a criminal offense. So we have a variety of federal offenses. I can't even tell you how many federal criminal offenses there are now. There are so many. But state offenses are particularly those that are violations of state law, such as DUI, murder, robbery, rape, those kind of things.
Yeah. Let's talk a little bit about the process.
Sure.
So obviously if somebody is arrested or charged with a crime, that is really sort of the beginning point. But a lot of times people are charged with a crime and arrested not when they actually commit the crime, but through what's known as a grand jury process. Can you talk about the different ways in which somebody can be charged with a crime and arrested?
Sure. On the state level, generally, what we usually see is a person is arrested either by a police officer who either sees a crime or offense committed or has what's called probable cause to believe that a offense is committed and this person is the person that committed that offense, and will arrest them. They will either do that by seeing an offense committed or via an arrest warrant where they would come out and arrest somebody. The grand jury process is another way that you could be charged but not arrested in the beginning. Generally, the grand jury process is further along. Generally, the grand jury process occurs when somebody is arrested, let's say for a felony offense, and their case goes through the district court level and then is sent to a grand jury, and a grand jury decides whether to indict, and that is meaning whether or not they find probable cause to believe that the person who's charged with an offense committed the offense. And it's a probable cause finding. If they find that, they issue what's called an indictment. Now, the prosecution can decide not to arrest you and present evidence to a grand jury, and then if they find sufficient evidence and indict you, then you're arrested on that indictment. And the difference is you are now at what's called the circuit court level. You're at the jury trial level, where with an arrest at the beginning of starting off with the beginning of it, then the case would travel through the district courts to a grand jury and then to circuit court.
All right, let's step aside. Just a few seconds remaining in this segment, but let's step aside. We'll pick up right there where you guys left off. Let's take our first break of the evening. As we do so, a reminder, a great resource, Hollis, Wright, the way they use social media, Facebook, Twitter, Instagram, you can find it all there. So check them out. Just search Hollis, Wright and you'll find it. Some really interesting things they keep up with and ways to kind of keep up with what's going on at the firm as well. Stay tuned. We've got more of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you.
When we started the show 8 years ago, my hope was we would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas. Bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, that's obviously the primary focus of the show.
We love helping people. I think everyone at this firm feels the exact same way, that the reason we do what we do is to help people. And this show gives us the biggest platform possible to help as many people as we can in the community.
Welcome back into the Attorney's. Really interesting conversation here. If you'd love to join it, we'd love to have you do so. Easy for you to do so as well. You can text us at 205-670-1949 or call us toll-free 844-LAW-TALK, 844-529-8255. Can I quickly get to a question?
Absolutely.
Right here? All right, a question here. If I'm charged with a crime in Alabama, is there a way to get that off my record?
It's called expungement. And it's probably one of the best things the Alabama legislature ever did in the last 20 years, and that is in 2014, they adopted the expungement law, which allows people who have been arrested but not convicted of a crime to petition a circuit court to expunge their record, basically wipe it clean. And it's turned out to be one of the best things for people who do not have a conviction on their record, because if you're arrested, that's a matter of public record, and that follows you. Not only follows you within law enforcement databases, but becomes a matter that can play out forever.
So if you're arrested and found innocent, it's still?
No. What I'm saying is, if you're arrested and found innocent, then you want to move to have it expunged.
Right.
Because if you don't, the fact that you've been arrested still exists. Yeah. So what has happened is now for misdemeanor offenses and for some felony offenses, that if you have not been convicted, i.e. you're found not guilty at trial, the case has been dismissed. If you've gone through a deferred prosecution program, or they just dismissed it for whatever reason, or if a grand jury does not indict you, does what's called a no-bill, so there's not enough evidence, then you can petition the circuit court in the jurisdiction that you're in. Let's say it's a municipal court, and you've been either acquitted or they dismiss the charge. Regardless of whether it's a misdemeanor or a felony, you can petition the circuit court within that county to expunge your record, to clean it. And that makes a big difference for, for folks.
And John and I realize this, maybe you didn't and maybe most people don't, but yeah, if you're charged with a crime, even if you are 100% found innocent, that charge is still on the books. They don't just wipe it off. You have to proactively ask to get it wiped off or expunged, as John was mentioning. But the key that I want to make sure that the viewers understand is, because we get a lot of these calls when we do these phone banks, people want to know if they can get their arrest record and conviction expunged. And that is, you cannot do that. No. If you are convicted or you plead guilty, there is no option to get it expunged.
No, Alabama has not moved forward yet on deciding whether or not to do that. Expungement only exists for those cases that have been dismissed, you've been found not guilty, there's been a grand jury finding of no probable cause, and that's it. If you've been convicted, there's no way right now to get that off your record, other than even if you're pardoned, it's still there. Even if you go to the governor and ask if it's a felony for a pardon, or if you go to a municipal court and ask the mayor for a pardon, the case is not expunged. It's not the record is not wiped clean.
Yeah. Now, if somebody's arrested, they're taken into the, county or municipal jail. What is sort of the next step in the process, or what could they reasonably expect to happen?
Well, depending on what you're charged with, the first thing that happens is you're brought into taken into custody and brought into whatever jail. If it's a felony offense, you're going to go to whatever county it occurred in. And the first thing that's going to happen is you're going to be processed, and that's their way of calling being booked. And that is basically they will get biographical information. They will inform you what you're charged with, and hopefully at that point in time a bond will be set. And a bond is basically a promise of release that allows you to be released from custody based on either putting a bond up or by maybe, depending on what the charge is, having a signature bond, which is signing a bond saying that you will return to court. Bond is basically your promise to return to court. And depending on what you're charged with, bond can be either potentially a signature bond where you don't have to pay anything. It could be a cash bond, which you could pay to the clerk's office of that county in cash for your release. It could also be a bail bondsman, which is individuals or companies that will make your bond for a fee, usually 10 to 15% of what the total bond amount is, or a property bond. And if you own property within the county in which you've been charged, and that property's fair market value is the same amount of the bond, you can pledge that property to secure your release.
And so just to make sure everybody understands, if it's a cash bond, if I'm saying this correctly, which most people probably are not putting up cash bonds, but if you put up a cash bond and you appear when you're supposed to appear and your case is resolved one way or another, you then get all that cash back, correct?
It's correct, especially if the case is dismissed or if you've been found not guilty, you get all of it back. If you've been convicted and there's fines or court costs that might be taken out of that cash.
Out of curiosity, since we're on, this is fascinating to me, right? Because you hear these things on the news. You hear where they say, got out on their own recognizance?
Yes, it's a signature bond. It's what's
is
called,
that what that is?
It's called an
okay.
OR, own recognizance, and that's basically where you sign saying it's your promise that you're going to return, and if you don't return, then you're liable for whatever the amount of the bond was that you agreed to do.
See, listen to you. We're rubbing off on you. Own recognizance.
That's it.
That's a big legal term there. So that's great. But as it relates to a bail bonding company, 10 to 15%. So if it's a $1,000 bond, you pay $100 to the bail bonding company, and that is non-refundable. That's just a payment for the bond.
That's their fee. That's their charge. You do not get that money back.
And then if you don't show up, you get somebody like Dog the Bounty Hunter or a local bounty hunter person is going to come out and find you and bring you to court because they don't want to have to pay the bond amount.
That's a real potential if you don't come to court that the bond people will bring you in rather than pay the amount of the bond. They'll track you down and find you and bring you in.
All right. So assuming you're going to get bonded out or bailed out, what is the next step in the process?
You're going into the district court, which is the lower level court system, part of the Alabama criminal justice system. It's the first court you will appear in. You'll have an initial appearance to find out whether you have a lawyer. Then a preliminary hearing will be set. And a preliminary hearing is where a judge decides whether there's sufficient evidence to believe that your case should go to a grand jury. And if the judge finds probable cause after a preliminary hearing, then the case will go to a grand jury. And as we said before, if a grand jury indicts you, finds sufficient evidence, then your case will move forward to the circuit court level, which is the jury trial level.
Do all felony charges have to go through the grand jury process in order for you to be held over for trial?
Yeah, you have to go through a grand jury eventually in this state to be able to get to the circuit court level for trial.
Because sometimes there are occasions where a case will go before a grand jury before it ever sees a judge and an indictment will be issued.
Yep.
In the example or illustration you just gave, a judge found probable cause to send it to the grand jury.
Yes.
Is the process at the grand jury stage different if it went through a judge already?
No, they're both making a finding of fact. The only difference is at a preliminary hearing before a judge, you get to cross-examine witnesses. At a grand jury, it is totally controlled by the prosecution, so they'll present whatever witnesses they want, and there are no defense lawyers there.
Yeah, the defense lawyers can't even appear, correct?
No.
All right, time for our final break of the evening. A lot of other terms we can get into on this second break.
I'm just going to pass it all over to you, David.
I've got a whole list. I'll go through them. Our final break, as we do so, we'd love to have you join the conversation. Just a few minutes remaining, about 6-7 minutes. So take advantage of that and join this conversation. Stay tuned. We're coming right back.
I'm Josh Wright with the law firm of Hollis, Wright. In court, attorneys are not allowed to tell juries certain things. For example, we cannot talk about a defendant's net worth, meaning the defendant's ability, resources, or insurance to pay a verdict. In this week's Legal 4-in-1, we're answering the question, why can't lawyers talk about a defendant's net worth to a jury? Now, Rule 403 of the Alabama Rules of Evidence states, in part, relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. Long-standing Alabama cases have held that the net worth of a defendant falls under this catch-all rule and is to be excluded. The reasoning behind the rule is that if a jury knows a defendant is wealthy, then the jury might award more money to the plaintiff. And this goes one step further. If an attorney makes any remarks that suggest the defendant is responsible because he is wealthy or rich and the plaintiff is poor, that can be grounds for a new trial. If you're ever on a jury, the reality in our state is this. In almost every lawsuit that goes to trial, the attorneys representing both the plaintiff and the defendant have already looked at whether there's sufficient insurance coverage or assets to satisfy a verdict. Most likely, the parties would not pursue a civil lawsuit if damages could not be paid after a jury returns a verdict. So even though lawyers cannot mention the net worth of a defendant during trial, there likely are resources available to pay a verdict in court. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. And remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. And as always, thanks for watching The Attorneys right here on WBTN 13.
Welcome back into the final segment of The Attorneys. We have just about 6:35 or so remaining in this program, so not much time left. We'd love to have you join our conversation. Just a few minutes to do so. Carter?
Yeah, so we've talked about the grand jury process and the preliminary hearing, and if there is an indictment, which I guess they call true bill, and then no bill would mean there's no indictment. But let's assume for the sake of this discussion that there is an indictment. What is sort of the next step in the process moving towards trial?
The next step would be an arraignment in front of the circuit court judge that's assigned the case. And then there'd be pretrial motions filed, any hearings in regard to suppression of evidence or otherwise. There'll be plea negotiations if that is wanted for me, if that's what the client wants to go ahead and do. Because you've got to understand, the majority of cases in the criminal system are resolved via some sort of a plea bargain and a brokered agreement between the prosecution and the defense in resolving the case without trial. Everything else goes to trial.
Well, and in the civil world, of course, we call it settlement if we're settling a lawsuit. And one thing that I run into with clients that I have is they mistakenly believe that at some point during the process, you can't settle the case anymore, which is not true. I mean, in my world, the cases can be settled at any point in time, and sometimes they can even be settled after a verdict is rendered. Is it the same in the criminal world? I mean, do you all have sort of a definitive point where there's really no more plea bargain or discussions that take place?
It depends.
Okay.
I mean, I've seen cases settle as a jury has been selected and is about to sit down. I've seen cases where there is no settlement offer. So there is nothing, you just go to trial. So it just really depends on the jurisdiction. It depends on the district attorney's office. It depends on what the client wants to do. So, you know.
Talk a little bit about the public defender's office a little bit, because I think one thing that the viewers want to know is if they have a family member that's been charged with a crime and they cannot afford to hire an attorney, what are their options here in Jefferson County and throughout Alabama?
You know, there's only, I believe, about 7 or 8 public defender offices within the state and all of counties. Most indigent defense is done either through a public defender's office, appointed counsel, or what we call contract counsel. So if you do not have the money to hire an attorney, the court will allow you to fill out an indigency form, which sets out, you know, what your financial situation is. And if you do not rise to the level of being able to hire a lawyer, here in Jefferson County, you'll be appointed a lawyer from the public defender's office.
Yeah, and I guess counties that don't have a formal public defender's office, do they just have a list of attorneys in that area that are willing to serve?
They do.
And basically get paid by the state of Alabama to defend those individuals?
They do. And then I still take appointed cases. I don't do I've been doing it for 32 years. I've always thought it was my duty as a lawyer, a criminal defense lawyer, to represent the indigent people too. Unfortunately, the ones I get charged, the cases I get mostly are the most serious offenses there are.
David, I think you had a question.
I do. Yep, a question here. When an individual is approached by a police officer, are they required to answer the questions? And if he asks for consent to search my car or house, do I have to give it?
Let me answer the second one first.
Okay.
No, you do not have to give consent to do anything. If a police officer knocks on your door at your house and says, hey, I'd like to talk to you, you don't have to talk to them. I'd like to come in and look around, you don't have to let them come in and look around unless they have a search warrant or an arrest warrant to arrest you to take you. So you're not under any obligation to consent to do anything. There's a statute that says if a police officer sees somebody in a public place doing something they reasonably believe to be a crime, they can come up, ask them for their name, address, and basically what they're doing there. I always tell people that, if you're asked for those kind of things, the biographical information, that's fine. But if you're being asked something more specific about why are you here, what are you doing, why, where were you last night, you're not under any obligation to answer those questions. And I always tell people, ask the officer, am I being detained? Because if you're not being detained and you're free to go, then you're free to go. And you should answer the question. If you don't feel like answering anymore, if you're not being detained, leave.
So for instance, if you get pulled over, suspected DUI, let's say, and they ask you to get out of the car and they try and start the process of a field sobriety test, you can refuse politely, be respectful, but refuse to participate in that process?
Yeah, not getting out of the car. You need to get out of the car.
Well, that was what I was going to other. Do you have to get out of the car?
Yeah, if they order you out of the car basically to do a field sobriety test, I would suggest you get out of the car for a variety of reasons. But
Otherwise you might get pulled out?
Yeah, you'll be taken out. You don't have to engage in a field sobriety test if you don't want to, and you don't have to blow a breathalyzer if you don't want to.
Now, do those result in a suspension of license if you refuse to do that?
If you refuse to take a blood alcohol content test, such as Intoxilize or Draeger, then you will lose your license for.
We could just keep on going, couldn't we? But we're just about out of time.
We have an hour-long show.
No, we need to just let everybody know. But a minute and a half left. I want to give both of you the opportunity for a final thought. And John, if you would, you go first, please.
The only thing I really want to tell people is if you've been charged with a crime or you are suspected of, you believe you're going to be charged with a crime, get an attorney. And when you do, look for these things. Look for experience, look for accessibility, and look for passion about their desire to help you. Those are the most important things. And don't think you can do it yourself, because there's nothing worse than trying to defend yourself without a lawyer. It can cause more problems for you than you can ever imagine.
Well, and I think John has indicated here tonight, he really knows his stuff. I mean, this has been his passion for over 30 years, is working with and alongside defendants who have been charged with crimes. He really knows what he's doing. And if you get in that unfortunate situation, like I said at the outset of the show, we hope that you never get in this situation.
Right.
But if you do, or if a loved one or family member finds themselves confronting an arrest and a prosecution, there is no better attorney than John Linton to give a call. He'll help walk you through the process and retain him or retain somebody else. But he's right. You need to get an attorney on your side early on.
Sounds good. John, Carter, thanks so much.
Thank you very much.
Enjoy the conversation. And as always, we're grateful that you joined us as well. Thanks for being with us. We'll look for you next time right here on The Attorneys. Have a great week, everybody.
Thanks for watching The Attorneys, sponsored by Hollis Wright.